Let's quickly get to this interview. We don't have too much time, so we've got to get into this very fast. The Democratic Alliance is seeking an order declaring key aspects of the Expropriation Act unconstitutional and invalid. The Western Cape High Court will today continue to hear the DA's challenge to the Expropriation Act. The party alleges that the process to pass it was faulty and unclear, and it goes against the constitutional protection of property rights. President Cyril Ramaphosa signed the Expropriation Act in January 2025. Now, the DA describes the Act of 2024 as being legislated land grab. For analysis, we are joined now by Bulelwa Mabasa, Director and Head of Land Reform at Werksmans Attorneys. Bulelwa, thank you for your time. Good to have you here on the program.
It's a pleasure, Leanne. It's good to be here.
So let's have a look at this and very quickly ask you, I want to get straight into this, is that the DA claims that 5 of the 7 provinces that voted for the bill in the National Council of Provinces lacked a lawful provincial mandate. So if the court finds these procedural steps were unconstitutional, will it nullify the Act in its entirety or simply refer it back to Parliament for a proper vote?
That's a very important question, Leanne. I think in our law, the constitutional principle that applies is that procedural fairness is as important as substantive fairness. What that means is that how you implement a process that leads to legislation can undermine can lead to the declaration of that legislation to be invalid. We already have examples of this, for example, with the Restitution Amendment Act of 2014, when President Zuma tried to extend the deadline for the opening of land claims. And that Amendment Act was declared invalid because of a procedural irregularity. So we do have case law and legal precedents that point to that fact. However, sometimes this procedural fairness, the courts and the Constitution in particular, has provisions where words can be read into a legislation, for example, where legislation can be brought back to Parliament for further revision. But it remains to be seen what approach the court will take as to the substance and the gravity of the perceived procedural illegality or unfairness.
What do you believe the strongest legal vulnerabilities the state must defend? What are they?
I think, in my view, it's the fact that the wording in Section 12.3 lists circumstances that allow the state to expropriate without compensation. It lists those factors. There's 4 of them: abandoned land, where buildings are unsafe, or where the state doesn't need it for its particular purposes. The counter argument is that the way that section is phrased, it's got words such as including but limited to, which could be interpreted that it can inadvertently widen the scope for the state to expropriate beyond those particular circumstances. But I think on the flip side, on the counter argument, is that the expropriation without compensation provisions are really the exception to the rule. The Act is still good in the sense that it still provides for just and equitable compensation, which is actually made provision for directly from Section 25 of the Constitution. So the Constitution actually tells the state what factors it must take into account when it expropriates, such as the purpose of the expropriation and all of those factors that are in Section 25.3.
Obviously what the DA are saying, and perhaps maybe you can just give us a little bit more clarity on this. Does the legislation truly, honestly threaten to legalize land grabs, as the DA is warning, or does it actually establish a heavily bureaucratized, testable process that perhaps protects private owners?
I think I tend to agree more to your latter opinion, or rather the remark that you've made.
Yeah.
And that is because this new act, unlike the 1975 Act, actually makes provision for just and equitable compensation, which is a step away from the willing buyer, willing seller previously. Number 2, what this act does, it actually provides the expropriated party, or the party who is subject to an expropriation, to so many safeguards, including new mediation provisions that were never there before, new arbitration provisions that were never there before, and ultimately the court is the court of final instance, even when parties are disagreeing with the expropriation itself and with the compensation itself. So it's in fact, I think it makes it even harder for the state to expropriate than than it was before. There are more hurdles for the state to get over, to get above, in order to get an expropriation to happen.
So if we see this successful, if the High Court strikes down the nil compensation provisions or finds procedural flaws in how it was passed, what happens to the rest of the Act's structural mechanisms?
Look, I think the Expropriation Act itself may survive if, for example, there can be reading in mechanics that are used, or when it can go back to Parliament. However, if the court finds that the procedural issues underlying the introduction of the Act itself were valid, then the Act can be struck down as valid in its totality. So this remains whether what the court approach is determines whether the Act can be declared invalid in its totality, or whether there are certain provisions that can survive and still maintain the Act, the legality of the Act to remain alive.
So we look at it now. If we go back to the 2021 constitutional 18th Amendment Bill failed. So how confidently can the state rely on Section 25's what it states, just and equitable mandate to defend a zero rand valuation without explicit constitutional change?
So it's such an important question that you ask, because on one hand, the one argument is that if you apply Section 25(3) in a specific instance, so for example, where the reason for expropriation is legitimate, where the way that the property was acquired in the first place was through donations by the state, and where there was no direct state investment, in a particular circumstance, you could potentially lead to zero compensation if you apply those four factors and if you apply the 25(3) formulation. However, those will be few and far between. So what the other counter argument is saying is that the reason that the amendment to the Constitution failed, and we actually didn't need to do it, is because already within Section 25(3), if you apply those 25(3) mechanisms in a particular set of a case, you could end up with zero compensation. However, it's an exceptional circumstance. It's not the rule. So this Expropriation Act doesn't do away with compensation. It just brings it along the lines of just and equitable compensation. And what the state needs to do is to apply the formula that is in Section 25(3), which is, what is the purpose of the expropriation? What is the market value of the land? What is the land being used for? And also, has there been any direct investment on the land by the state, and so forth?
Yeah. Well, I look forward to seeing this continue, because obviously it continues on today, and it'll be interesting to see how allowing nil compensation inherently violates Section 25 of the Constitution, which mandates just and equitable compensation. So it's going to be very interesting. But Bulelwa, thank you. We've got to leave it there. Bulelwa Mabasa is the director and head of land reform at Werksmans Attorneys, unpacking that Expropriation Act challenge.